Today I would like to speak to all of you about cheating at the courthouse. When you have a contract and promissory notes and a general release and an agreement not to sue if your debtor doesn't pay you, one would think if the person fails to satisfy his obligations that you are in like Flynn in collecting at least a judgment and probably your money. But think again when you're dealing in the courthouse in New York, because it doesn't work like that. I have a situation now which is somewhat sensitive because there is a restraining order where we're not supposed to be talking about the case or the principles involved in the case. So I intend not to do that, although my adversaries have done it repeatedly. But I am going to talk to you about the conduct and misconduct of the law firm representing my adversary, which has been ongoing for at least 4.5 to 5 years. I have a situation now where this particular obligor, the defendant in this case, owes me and companies I'm involved in $20 million and has squirmed and failed to pay these obligations for over 5 years. Although every single agreement that this man has signed was prepared by himself or his lawyer attesting to these obligations. He signed promissory notes, he signed settlement agreements, and he signed general releases. When I finally got disgusted after he told me he was going to pay and repeatedly defaulted, I sued him. Enter Russo and Burke, who prides themselves as being resourceful, innovative, and trustworthy. And Joe Burke, one of the senior partners. I will tell you, Joe Burke is certainly resourceful and he's certainly innovative, but he's about as trustworthy as a cobra. What Mr. Burke did from the beginning was first concoct a series of counterclaims that were barred by the virtue of the agreements that this man signed, and then proceeded to harass me unmercifully, file frivolous charges against me saying I was harassing his client, proceeded then to engage in a series of behaviors that one would not believe unless one were there listening and observing day to day what was happening. Mr. Burke secreted material evidence. Mr. Burke fooled at least 4 referees. Mr. Burke interfered with the conduct of referees and, as a matter of fact, secreted a filed note of issue, which means that once a note of issue and certificate of readiness is filed, no further discovery is permitted. Mr. Burke, knowing that, proceeded to demand more and more discovery, manipulated and conned the appellate division, got my complaint in one of the cases stricken on fraudulent grounds, and then proceeded to compromise another referee where we caught him engaging in ex-parte communications and writing orders to deprive me of my legal rights and to secure a $7 million judgment against me for their frivolous counterclaims. Now that's not bad enough. When I caught him doing that, he continued on, interfering with my witnesses, interfering with notaries, concocting stories that I'm a forger, when all I've been trying to do is to collect money that's properly due to me. Now the problem here is that the courts seem to be unwilling to look at the facts and are happy to look at the diversionary conduct of Mr. Burke. When I uncovered that Mr. Burke's client engaged in massive tax evasion, nothing happened. When I uncovered his conspiracy with a referee and documented it with ex-parte emails, which fortunately were preserved by a friend of mine, nothing has been done. When I uncovered the violations of the restraining order by these people, nothing has been done. How can this be? How can it be when you have documentation and admissions of the obligations entered into that you can't collect your money? How can it be that a lawyer can continue to corrupt the system, fool the appellate division, where the appellate division writes an order saying that discovery was legitimate, when in fact it was not legitimate, when in fact the discovery was barred and precluded by the filed note of issue that Mr. Burke secreted in the first place, and then when the appellate division is called to the attention of these facts, do nothing about it. That's a frightening situation. Mr. Burke is certainly resourceful. He's filed claims against me with law enforcement, all to create a situation to deprive me of my legal rights, my rights to due process, and continuing to willfully obstruct justice, to steal money that was entitled to me and my companies by this principle that Burke represents. The most important thing that Mr. Burke did that is a crime is not only tampering with people and tampering with court officers, but it's the spoliation of evidence. Spoliation means the secretion of material evidence that adversely affects your adversary. Mr. Burke secreted a note of issue and a certificate of readiness and allowed 3.5 years to pass of discovery ongoing that he knew was barred and illegal by the uniform rules of the court. Mr. Burke continued to allow referees to fault me when Mr. Burke knew that everything he was doing was illegal. Mr. Burke knew that I was sick and in the hospital, and knew that I produced tax returns and lied and said I did not. Now, this course of conduct is not the way a litigation is supposed to be run. Unfortunately, for whatever reason, possibly because I'm pro se and possibly because I'm not a lawyer and possibly because I've been ill and hospitalized at least 6 times in the past 3 years, that the judge now that is handling the case wants to believe Mr. Burke. The problem also is that there's no question that Mr. Burke has compromised people that have come forward, such as a notary. Now, that's a serious problem. Mr. Burke knows the law. Mr. Burke knows that his client owes me a substantial amount of money, and Mr. Burke knows that he secreted material evidence. I think it's about time that Mr. Burke stops being resourceful and innovative and starts being trustworthy, because in the courthouse, everybody is entitled to a level playing field. And when you're trustworthy, you're supposed to act trustworthy. You're not supposed to compromise people to serve your own interests. You're not supposed to make up stories to serve your own interest. I am now prepared to say that I believe that we have uncovered sufficient evidence to show the court that Mr. Burke has again lied and tried to deprive me of my right to due process. Mr. Burke's had the audacity to claim that I forged my own signature to my own legal documents, and then somehow forged a notary signature, which the notary admits is not even close to her own signature. I would submit to Mr. Burke that if I were going to do such a dastardly thing, I would be a little more careful about it. This was a setup, just like Mr. Burke tried to set me up with Souter, just like Mr. Burke set me up with other referees, just like Mr. Burke lied and said that I didn't produce certain documents when evidence points to the fact that I did, and just like Mr. Burke going to prosecutors saying that I stole this man's money when the tax returns that I presented are as proper and in order and reveal that I and my companies lost a substantial amount of money. Mr. Burke, it's about time for you to stop conning the court, and it's about time you stop trying to misuse the system, because I assure you, Mr. Burke, eventually this will catch up with you and your client.